The next case, Buckland and Bournemouth University Higher Education, it's on constructive dismissal. The key points from the case being set out on the slide there, the more interesting one being the second point about repudiatory breaches not being curable. So in that case, the employee was a professor of environmental archaeology at the university. His duties involved marking papers, exam papers among other things, and he marked 16 resits in 2006, failed 14 of them. Now that marking was endorsed by a second marking process and by the board of examiners. However, the program leader for the course got the papers remarked anyway without any authority, and the chair of the board of examiners also had those papers remarked again. And the employee protested against this, following which there was an internal inquiry which vindicated the employee, but the employee was still not happy because he felt the remarkings were an attack on his integrity, being a fundamental breach of contract, of breach of the duty of trust and confidence, and he therefore resigned. The tribunal upheld the claimant's claim for constructive dismissal and made the point that the university's internal inquiry did not cure its original fundamental breach of contract, and the Court of Appeal agreed with that and said that an employer cannot cure its fundamental breach of contract. The reasoning behind this being that the wronged person should have an unfettered right, an unfettered discretion to decide what to do once a fundamental breach of contract has occurred, i.e. whether to accept the breach and terminate the contract or to keep the contract alive. The next case is a simple breach of contract case involving wording in an employee handbook, where the company reserved its right to review, revise, amend or replace the content of the handbook from time to time, and the handbook also contains certain contractual provisions relating to pay and holiday, as well as non-contractual policies. And on the basis of that right, the company here unilaterally changed certain terms of employment relating to the employee's pay, and the Employment Appeal Tribunal said that that is fine, the principle being that an employer may reserve a contractual right to unilaterally amend particular aspects of the employment contract, but clear language should be used in communicating this right, this power. And in this case it was felt that the wording of the handbook was clear enough. However, it is important to note on this point, as set out on the slide, that in this case the employees did not, for whatever reason, argue that the unilateral change to their contract was a breach of the implied term of mutual trust and confidence, and query whether the result may have been different if they had. But I would suggest that you all go back and check the wording of your employment handbooks and the power to amend contractual terms. And the final case is in relation to concurrent disciplinary proceedings and criminal investigations, a point that does come up quite frequently from time to time. Now, the normal view is that a police investigation taking place is not a valid excuse for delaying completing an internal disciplinary procedure, and that is also in line with the ACAS code, which requires each step of the code to be taken without unreasonable delay.